we're focusing largely on not the changes that have occurred, but the bills before Parliament at the moment. And you'll be familiar with some of the changes to the minimum wage, the parental leave and protection employment changes. And so really focusing on the bills before Parliament, some of the key ones in regard to the employment reforms that are forthcoming or are likely to be forthcoming. I guess it's really important to remember that every change of government brings with it a change in I guess, political and philosophical focus. We've got a Labor-led coalition government. They've been very assertive both in their campaigning as well as in their first 100 or so days in terms of the changes they want to see in New Zealand and the way the country is governed and operates. We're focusing on the employment changes, but please remember, a bill is just a bill, and often it starts off in an incubation period as a bill. It goes through its various readings in Parliament and ultimately ends up in a select committee, or usually ends up in a select committee process. And from that, often there are amendments to the original bill or changes to the original bill. So what I'm talking about today is more about what's proposed by change of law rather than the law itself. So please, please, please don't go back to your workplace, throw your hands up in horror and say, we've got to do this by Monday next week. The Employment Relations Amendment Bill, submissions don't close till the 30th of March this year. And from that process there'll be a further review by the Select Committee. They'll make submissions to Parliament, and then from that the bill will probably evolve into an Act, at which time it will then be implemented. The purpose of today's session is also hopefully to focus you on the changes that businesses need to think about at this point in time in terms of changes to legislation. My view, our view as a team, is that you're better off leading from the front in terms of statutory or law change, and you're better off leading the processes in your business in terms of being ready for the change in law rather than reacting when it occurs. So part of today, and if I'm successful, you'll be thinking about your business, you'll be thinking about some of the things I'm talking about, and you'll be thinking about the impact on your business processes, your employment processes, right through from recruitment to the time when people terminate their employment for whatever reason and under whatever circumstances. And the big bit, of course, is what happens in between the recruitment process and when an employment relationship ends. The bottom line is, law changes that I'm going to brief you about or talk to you about will inevitably impact on business in New Zealand and employment relationships. Things like the fundamentals of how people are going to be paid with the pay equity legislation or bill in front of the House, and the legal framework by which you can operate whether you're a union environment or a non-union environment. The Honourable Minister of Labour, Ian Lees-Galloway, has made it very clear that the government has got an agenda for change in employment, some of it quite radical and some of it probably less than radical. And what we're seeing already in terms of some of the philosophy, I guess, of change is that the government is already looking to introduce a much more codified set of minimum standards for the protection of employees. And that's a strong focus. The government is unashamedly saying we need to address the imbalance between employers and employees. And so the minimum standards and minimum codes that they're looking to introduce are very much from the government perspective about protecting employees in the workplace and the work environment. They're also looking to very much promote or re-promote, in fact it's a bit going forward to the past sort of situation, but promote the ability for unions in New Zealand to recruit, to enter workplaces and to have an impact in terms of collective bargaining and those sorts of things, and I'll talk a bit more about that. Again, one of the fundamentals is that The government philosophy, whether you agree with it or not, is that the government believes that they need to promote through legislation a greater degree of fairness between employees and employers, and to promote more productive workplace environments. I will make comments, and it's my opinion rather than necessarily correct, but I would have said that there's been some pretty good stuff going on in workplaces in the last decade almost, in terms of productive and progressive employment relationships. But the government's agenda is they think they can help us do that better. Looking at the legislative change, I did a bit of research over the weekend. There are currently 30 bills before Parliament. So that's a big legislative agenda for any government. One of the ones I want to focus on, obviously, are in relation to employment, and one of the ones that you may not be so familiar with, and I won't be talking a lot about today, but you may want to keep a watching brief on this, is there's actually a Health and Safety at Work Volunteer Associations Bill, which is looking at the issue of voluntary organisations and the volunteers that they engage, and how the Health and Safety Act intertwines with that responsibility. So it's really looking at where a volunteer association employs no more than 100 people, and whether or not the Health and Safety at Work Act can look at excluding PCBUs, people in control of business and undertakings, who are the person or the identity liable for that. So well worth just keeping a watching brief on that. It's not high profile, but it is a relatively relevant bill if you're in a volunteer association. Going to look at the Employment Pay Equity and Equal Pay Bill, which is before Parliament currently. I think it's had its first reading on the 22nd of February. That's a follow-on from the IDEA Services decision that came out of the Employment Court and the Court of Appeal in terms of the caregivers and pay equity issues that were addressed through that process in some sectors. So that's really looking at broadening the scope of that whole process to address pay equity in other sectors, and in terms of not creating discrimination, particularly for female or women employees. Employment Relations Amendment Bill, that's the big one. That's the one that gets me excited. Yes, I know, sad, but that's got a number of codification changes, such as minimum wage, but it's also got quite broad-reaching implications for changes in the way, as I said, relationships with unions and such like operate. And the other piece of legislation that is quite interesting, and I think probably needs a watching brief, is the Employment Relations Triangular Employment Bill, which is before Parliament as well. Nothing to do with music, and it's more to do with the tripartite or the three-party arrangement of a contracting company providing contractors to a second or third party, and how that relationship can be expanded to allow the contractors' employees to be covered by some of the changes in the Employment Relations Act. The other one that you might have heard about was just on the cusp of the election, there was a bill before Parliament which was about allowing higher earners to contract out of personal grievance provisions. You might be familiar with that, you might have heard about that. Checked on that again today. It's a bit like being at school, isn't it? The commentary next to it is failed/withdrawn. So that's not going to go anywhere in this current legislative cycle. But that was about higher earners being able to contract out of raising personal grievances. So you'll be familiar with some of the codes of practice or the codes of employment that have changed already. I don't want to go over these in great detail, but I want you to think about the implications for your businesses. We're looking at $16.50 from 1 April as the new minimum wage, moving from $15.75 as it is currently, and as it has been for the last year. But there's a declared agenda by the coalition government to move the minimum adult wage to the $20 mark by 2021. Now that's probably great for people who are on the minimum wage. What you need to think about as a business is what that's going to do for your pay rates across the spectrum. So if you pay people more at the bottom of the scale, what's it going to do in terms of expectations and movement at the other end of the scale? I'm not talking about your chief executive or your managing director, but the people in between who are going to see a breakdown of the relativities between the difference, if you like, between the minimum wage where it is at the moment and where they're being paid, maybe $25, $28. When the minimum wage in 2021 moves to the $20 mark, that differential is going to reduce quite considerably. And of course, wages are a means of value of an employee or for an employee. That's probably going to put some real pressure on your remuneration frameworks, your remuneration structures, and how you go about paying people. I don't think there's any magic pill if this proceeds, and it probably will by 2021. The $20 rate will definitely put some pressure on your relativities. What's that going to do for your business? Okay, to pay people more, which is probably great, you're going to have to generate more revenue or more income, or you're going to have to look at the other option at the other end of the financial scale of taking, I guess, less in the way of a marginal profit out of your business in terms of paying people, being able to pay people more. Is it going to mean that you actually have to rethink the number of people you employ in terms of labour costs overall and how you run your business? Now, I don't have the answers for those sort of questions, but I think it's something well worth thinking about in terms of the minimum wage moving. The parental leave, obviously well advertised and well covered by media, but there's a progressive increase again occurring between moving from 18 to 22 weeks paid parental leave from 1 July 2018. Again, that's a taxpayer-funded payment, obviously, but it does show that there's a significant move by the government to want to increase the pay benefit or the payment of parental leave for both partners or the partners in a relationship. And the agenda again is to actually take that beyond that in 2020 to 26 weeks, so 6 months. And I guess the implications, I've been thinking about that. You know, currently you can have 52 weeks parental leave anyway. The difference, I guess, is that the 26 weeks is going to be paid during that time rather than what it was a few years ago and what it is now. Is it of major impact on businesses? I've been struggling to see how it is, but some of you might have a different view on that. Then we've got as I said, the Employment Relations Amendment Bill, which is well and truly before Parliament at the moment and right in the middle of a select committee process. And we've got the Triangular Employment Bill as well as the first reading of the Pay Equity and Equal Pay Bill that's just been launched. So I've talked about the government wanting to introduce, I say again, I've been around long enough to see government cycles and employment legislation change a few times. And you might recall that in terms of minimum standards, a lot of the older or earlier iterations of the Employment Relations Act had codifications in them in terms of paid meal breaks and paid rest breaks and such like. What the government's unashamedly said right through its election campaign is it was going to have a look at that 90-day trial period that was introduced by the national government. The initial version of it was, it's gone, you know, we're going to get rid of it. But you will have read, no doubt, that there's been consideration of that with the coalition partner, New Zealand First, and the government's made it very clear that as part of the amendment bill, they're looking at changing the 90-day trial. This is the 90-day trial where you can avoid a personal grievance claim if you dismiss within that 90-day trial, to allowing it to continue to occur where there are 20 or less than 20 employees, which I guess is 19, isn't it? So if you've got a business of 19 or fewer employees, you could still use that statutory trial period. That's currently in the Act, but any business over 20 or 20 or more employees, definitely that is part of the agenda under the bill to remove that provision or that clause. Again, some of you might say, well, we haven't used it anyway. Others might say we've used it extensively. The question for you is, what are you going to do if you're over 20 or 20 or more employees and you do and have relied on that 90-day trial? One of the solutions, I don't know everything by any means, is that some of you will recall or know of the sort of a probationary period that was often used in employment agreements and employment terms prior to the 90-day trial, and perhaps even well prior to the Employment Relations Act coming aboard. But if you are looking at a probationary period, you are not going to escape the liability or the risk of a personal grievance claim against you if you're 20 or more employees, and I think that's if you're going to look at that sort of provision once the bill is passed, and providing this does go through, which I think it will, you need to make sure you've got a very structured and very well managed process around that probationary period, because the law will still apply in terms of unjustified dismissals or disadvantage or discrimination if you use a probationary period to ultimately terminate employment. If you do, you are liable for or could be liable under the personal grievance provisions. When I say structured and well-managed process, it's about making sure that if you do employ somebody on a probationary period or a non-statutory trial period, and you need to be very careful about the language you're going to use there, then you do need to make sure that you've got systems in your business that actually look after that process, look after you as an employer or an employee in that process, mainly because of the risk of a personal grievance. It's interesting that I read research around 90-day trials as well as other things. Yes, I know, don't say it. But there are only 4% of collective agreements throughout the country currently registered with the MB that actually have a 90-day trial provision in them. So you've got to ask yourself why this is a big problem, because most collective agreements are negotiated in larger forces, usually over 20 people, not always, but usually. And I guess if you look at the larger businesses where there are collectives, if there are only 4% of those collective agreements with a statutory trial period included in them, then it doesn't seem to be an awfully big problem. So it's actually not about the problem, it's about a philosophical difference between one government and the other in terms of, is a 90-day trial a right thing to be doing or the right thing to be doing? One of the other things that the bill is proposing, and I would imagine we'll see go through, is the changes to it's often called the vulnerable workers provisions in the Employment Relations Act. You'll be familiar with that. That normally affects lower paid staff, cleaners, some sort of very domestic or very low-paid roles, largely cleaners actually, and the government's looking to remove the exemption that currently exists in the Employment Relations Act. Now, the way it sits at the moment, if you have 19 or fewer employees and you're transiting your business, your cleaning business or your cleaners from one business or one owner to another, one employer to another, you can seek an exemption from the transferability of those employees from employer A to employer B. What that, I guess, the implications of that currently under the law are that if you have 20 or more people who are protected employees under that provision of the Act, then you've got to negotiate, and the new employer has to take on those employees. If you've got 19 or fewer, you can seek an exemption from that requirement. The government under this bill is going to remove that exemption. So if you're in a business where you have vulnerable or protected employees, and if you are looking to sell up or contract out or transfer that part of the business to another employer, then you will no longer be able to seek an exemption. You'll be subject to the same obligations that are currently existing for employers with more than 20 or more employees. They're also, as part of that, looking to extend the time frame around the transfer provisions. When you sell or transfer a business and employees go with that sale or transfer, they're also looking to extend the time frame that has to be used around that. So you can't just whip in there and do it. You've got to spend a fair bit of time working with the new owner, buyer, future employer to make sure that you get you obtain a transfer of your existing employees to that new employer. Another significant change, again, this is again forward to the past, excuse my cynicism, but you will recall that the Employment Relations Act did have specifically codified and stated timeframes for when paid rest breaks and when meal breaks could be taken. That was by change in statute, amendment to the Act, that was removed by the national government, I think 2013, if I recall correctly, or it might have been 2016. The government currently is going to put that back. So not a lot of difference really to what was in place. It's almost, as I say, it's forward to the past in terms of what was in the Act was taken out, what was taken out is going to be put back in. But it's going to again codify the taking of paid breaks, you know, the morning and afternoon tea or whatever they are, and also the timing and taking of an unpaid meal break, and it's over about 4.5 pages of the Amendment Act in terms of codifying every possible scenario in terms of how long people work for. If you're talking about the 8 hours, then typically it's as it probably is in many workplaces after the first, well, between the 2 and 4 hours of work, first 2 and 4 hours of work, a paid 10-minute break's got to be granted. There are some other little curls in the tail of the amendment bill, and one of those is that if you can't provide those breaks, and that's covered by the essential service concept, then you can negotiate with your employee or employees as to when those breaks are taken away from that codification or that time framing. But you do, as you do currently, have to provide compensation by way of paid time or paid time and financial compensation to make up for that. Where you're allowed to waiver from the actual stated times or windows for breaks is the essential services. And I guess what the bill is saying is that an essential service is classified as, how do I say it simply? I guess it's, if you allowed somebody a break, it would not be in the public safety interest or public good for them to do that. Think of an example. I guess maybe a security guard somewhere where there's a 24/7 coverage on a site. They're working on their own at night. They can't just stand down for 10 minutes and go off and have a morning a smoko break or a tea break or whatever it might be and leave a site unsupervised or without security. So in that situation, you could argue there might be a public safety issue, and so that person could, you can negotiate with that person to allow them or to have them on duty, probably take their break on duty, but also compensate them at the end of it for that time that they didn't get, if I can describe it like that. The other one that's fascinating to me, and again my theme of forward to the past, is the bill is promoting the reinstatement as a primary remedy where practicable and reasonable. Now, in the early days of the Employment Relations Act, the law provided reinstatement as a primary remedy. What that means is that if there is a personal grievance and if the grievant is successful in their grievance in the authority or the employment court, then the court or the authority would have to look at reinstating that person back to their previous job as a primary remedy. It was the first course of action. My recollection, both of case law and our own work, is that reinstatement provision in the previous law was not used a lot because the court and the authority both looked at what was reasonable and practicable. And I guess if you think about a simple scenario, Dave Robb's dismissed, he doesn't agree with it, strange as it might be, he raises a personal grievance, he goes off to the Employment Relations Authority, after having been to mediation and all the argy-bargy that goes on between various parties before you get to the authority or the court, you might be in the authority anything between 6 and 18 months after your dismissal, my dismissal. I win my case, I feel pretty good about that, and the authority says, well, actually your attitude during the hearing towards your previous employer is just toxic. I don't think it would be reasonable or practicable to put you back into that workplace, so I won't award that even though it's a primary remedy. And that seemed to be the mindset of the authority in the court when reinstatement was available. That was wiped away by the previous government, and instead of the reinstatement option, I guess the remedies were the age-old remedies of minimum of, or up to 3 months loss of earnings or more sometimes, and compensation for the grievance, for the personal grievance. We're going back to the reinstatement option as a primary remedy, but I'm not so sure that that's going to matter much. You come and tell me I'm wrong in a couple of years, but the reinstatement option has got that curl in the tail, or the sting in the tail, in terms of it being reasonable or practicable and reasonable. So the authority of court are always going to look at just how successful that could be. But be aware that is coming back, and it may have implications for how you go about terminating in a disciplinary context or a performance context or even a redundancy context, being mindful that if you do get it wrong, that reinstatement could be something that's awarded. And I always remember, I think it was a case in a timber mill in Gisborne, in a court case, and it was about a 3-year litigation process. It went right through to the employment court and I think to the High Court. And essentially the High Court ordered reinstatement a couple of years ago for this person who probably wasn't the most desirable of employees. And it was basically, he walked back in the next day, honey, I'm home. And he was very proud of the fact that he'd won his case. But the business had moved on in 3 years. And the reality of him just integrating straight back into the business was not practicable and probably not reasonable. We've grappled with that under the current law in terms of the 19 or fewer with the protected employees situation. Our view is it's full-time equivalents. Does that answer your question? So I think you're talking about FTEs. I think not clear in the bill and wasn't clear in the previous law. But there's been no case law actually where it's got to an authority or court in terms of challenging that particular component of the current Act as to what 19 or fewer means. Is it 19 full-time equivalents or is it 19 people? We debate often in-house about whether it's 19 individuals or 19 FTEs, and we have different views on that. We're both right at this stage because we're not proven wrong. That question I think will be answered through select committee, and the bill will be amended to say 19 individual employees, irrespective of whether they're full or part-time, or it'll be 19 full-time equivalents. I think they're the only two answers that can come out of that, but I don't know the answer to that at the moment. "20 or fewer, do they count shareholder employees as staff?" Is that the question? If you're an employee, you're an employee. The shareholder, I think, is secondary to that. That's the way I would read that. So you're wearing two hats as a shareholder employee. One is as a shareholder and I guess a part owner or an owner in a business or whatever. But if you're engaged as an employee in that business, then you would count as one of those 19 or 20, I think. Yeah. Sorry, that's not going to work, Ewan. No, because no, it hasn't. Because most tests over the sale transfer of a business and protected employees has been in a larger business or larger sale where there have been a lot more than 19 or fewer employees. So the test in that case has been whether the employer behaved as per the law in terms of endeavouring to transfer the employees over, offering the new employer, the new owner, offering that employment to those existing employees of employer A, shall I say. So that's where the test case stuff's come from. It hasn't actually looked at what do we mean by 19. So it's interesting, actually, since that's been in the Act, there's been no real challenge to it. Or if there has, it's probably been below the horizon, never seen the light of day in the authority of the employment court. So parties have resolved it somehow or another. Yeah. But again, that is for those protected employees. I wouldn't mind betting, again, opinion, speculation, is that we'll possibly see the scope of those protected employee roles expanded as well, because part of this is about a government agenda to protect people who are vulnerable or who should be protected because they're low paid, often don't have the impetus required to speak for themselves. The way the bill is structured is that it's at the time you enter into the employment agreement, not the time they start, but the time you enter into an employment agreement. I didn't mention that because it's reasonably complex and hasn't been tested through select committee yet. But what they're saying is this: if you're a business of fewer than 20 employees, you want to use the 90-day trial. The day you enter the employment agreement with them, which could be a week or 2 weeks or a month before they actually start, that's the defining date for the test of the fewer than 20 employees. So I guess there's going to be ducks and drakes played around that, aren't there, in terms of when you offer the employment. But it's also going to be quite
probably
a good word. Yeah, but
some people on 90 days, some on not.
Yep. And the transitional provisions too could be quite complex in terms of where you already have IEAs and 90-day trials. What's going to happen for the people in those 90 days if the new law comes into being, in terms of, are they bound by what they entered into prior to the law changing, or does the new law impact on them from the day it becomes law? I don't know the answers to that. It'll be around about timing, and it'll also be about transitional provisions that they often put into the Act, in terms of if you're already covered by these terms, the new one is not going to apply for a certain period afterwards. I suspect that's what they'll do. They might say the law, let's say the law goes through and gets royal assent October. They might not say some of these changes, they might say in that law that some of these changes don't occur till the 1st of March 2019, which means that 90-day can be planned for in advance.
So utilising the probationary period would be similar to a performance management process?
Well, my instincts are that people just love performance management processes, but essentially you're right. If you're going to put a probationary period in, that's non-statutory in terms of the 90-day statutory trial, you're going to have to manage people through that process. And that's why I talked about being structured and being well managed in that process. If you're going to employ somebody on a probationary trial or probationary period, or whatever you want to call it, it could be 6 months. Not suggesting that's a good idea, but it could be. You're going to have to manage and time frame and have a structured approach to providing feedback and performance management right through that process, including warning processes and all those sorts of things. I think that's probably going to be a new field of excitement for lawyers and employee advocates, in terms of if you are using a probationary period and you muck it up, you're going to be fair game. Yeah, one of the things that changed in the Employment Relations Act was the codification, or the specifics around using a fixed term employment agreement. And it's got to be for legitimate and lawful purposes. And the underscore of what's in the law at the moment is that you can't use a fixed term agreement as a trial period, because it's not seen as a lawful or legitimate use of it. That's the way the law's sitting at the moment. I doubt that this government's going to change the philosophy behind that fixed term agreement arrangement. I know what you're saying, and I know it happens, but there are defined reasons for using a fixed term agreement in law, and if you don't comply with those defined reasons, then, and maybe use it as a trial period, then you could expose yourself to a personal grievance. If you want to talk a bit more about that afterwards, I'll give you a bit more detail. Without offending anybody in the audience, often that's a union approach to bargaining, is, we'll just leave that clause in there just in case. So I guess as an employer you could use the same approach, couldn't you? As, let's leave the 90-day trial in there. We can't use it because it's not lawful, But if there's a change of government in the future, we won't have to re-bargain to get that 90-day trial back into the collective. Bit of a cynical view on my part, isn't it? But that, that sort of thing does happen. If it's in there and the law changes, it's no longer enforceable. You'd know that. So the question is, would all existing contracts or agreements need to be changed if they've got a 90-day trial provision in them? No, because after 90 days that becomes non-effect. The only time you might have to change agreements is if there's a transition period that impacts on the 90-day trial. But you'll be thinking about that. The law won't suddenly happen overnight or change overnight. And that's why I say part of this session today is getting you thinking about the what-ifs. What if the law does change, or when the law changes, what are you going to do about your employment practices? What are you going to do about your employment agreements to make sure that they're going to comply? You don't normally have to leap into action immediately and change the world, and certainly don't do it tomorrow. If you don't have collective agreements, I think there's still a takeaway here for you in terms of a change in government philosophy, and part of that is changing the law to give employees more protection, and part of that is also to boost the influence of unions and the union movement in New Zealand workplaces. So what's that mean in practical terms? How do I translate that currently? I'm talking or negotiating quite regularly with unions. There's a great joy amongst the union movement at the moment with these law changes, and the fact that union organisers, union representatives will be able to come into sites that they might have had difficulty getting into previously or onto previously in terms of recruiting and engaging in collective, recruiting union members first of all, but then wanting to engage in collective bargaining. I don't want to put the fear into you about that. Some businesses that you come from won't be of any interest to a union. But the larger work sites, or those where a multi-employer collective agreement would have some merit, and I'll talk a little bit about that in a minute, may leave you as a business that is something that the union are interested in. Just some interesting information about collective bargaining. In 2001, there were 403,000 employees in New Zealand covered by collective agreements. 2001, quite a long time ago. By 2017, that had dropped to 323,000. So quite a big diminishment of membership of unions and collective agreements. And 40% of those people of that 323,000 in 2017, 40% were in government sector organisations, so police, teachers, nurses, those sorts of sectors. So there's been a huge move away from collective agreements in the private sector, and probably a strengthening, but a marginalisation or reduction of the number of collective agreements and people in collective agreements in the state sector. That's in contrast to a growth in jobs last year, or over the last 12 months, 16-17, the estimate was 42,500 growth in jobs. But again, you still didn't see a big growth in collective bargaining or collective membership. So, I guess that's creating some interesting dynamics for the union movement as well, in terms of how do they get to grow the union membership, and how do they get to grow the union movement again, and how do they I guess, then implement this collective bargaining process. And whether you're a union advocate, supporter or not, unions are businesses. And at the end of the day, they've diminished in size over the last 10 years because there's been a diminishment in membership, which is a diminishment in income. So the big challenge, and I've talked to some of the union organisers about this, is that with the excitement of this bill becoming law, they will not have the capacity of people on the ground to actually do some of the things that the new law possibly provides for. Now, again, I could be completely wrong on that count, but you've got to have the resources if you want to build your numbers, and you've got to also have the ability to sell your product, which is, I guess, is union membership. So what's changing? Well, the bill is providing for unions and their representatives to carry out duties in supporting their members, and a member could be one person in your workplace, it could be all of them, it could be part of the employment base. And they're going to try and empower the union to do that, or the unions to do that, by changing the law to allow delegates paid time to represent employees during normal work hours. At the moment, if you're a unionised site, there's kind of a permissive process where a delegate has to ask permission to take some time during the day to go and do union stuff. This seems to be saying that there won't be that quite high level of permission required, and that the law will allow delegates, so they're your employees who are union members delegated by the union as delegates, to represent employees during normal work hours. Whether you agree with that or not, it's probably going to happen. And if you are on a site where there is a union delegate, even if you don't have a collective, you need to be mindful about the ability to run your business and the ability for that person not to be interfering or damaging your business if they're going to be, going off doing a union business. They're also removing the obligation or the requirement currently in law for a union representative. So that's an employee of the union, a union organiser often referred to. They currently have to seek permission to come onto your site and notify you of who they are and why they're there and who they represent and all those sorts of things. And you can object to them coming onto site and coming to visit you. That's going to be removed, and again we're sort of forward to the past where union organisers could essentially stump up to your workplace and say, I'm here, I want to see some of my members, or I want to go and recruit new members. So that's a change in the law, it's again, as I say, it's a little bit of going back to the past, or forward to the past really, in terms of entering the workplace is going to be less structured, less formalised, and you won't have the same ability to say go away. One of the other things that is changing, again it hasn't had a big impact to my knowledge, is the law was changed by the national government, I think again in 16, or it might have been 13, can't remember now, 16 I think it was, where if there was a partial strike you could deduct wages for that partial strike. The current government, and through this bill, is saying we're going to get rid of that. If somebody goes on a partial strike, then we're going to remove your ability to deduct pay for that period of time not worked. And I guess that's got implications, because what it could do, again once this becomes law, or if it becomes law, is it's going to encourage the sort of the partial strike where we're going to walk out for an hour and disrupt your business or whatever it might be, and the employer will have no recourse in regard to deducting for that time not worked. Is it a biggie? Larger work sites, yes. Smaller workplaces probably won't worry you. That would be my anticipation or estimation of the situation. Again, some of the other changes that the government's proposing. Currently, you're not mandated or required to conclude bargaining. You can carry on bargaining for 4 years and not conclude it, not finish it. That is going to be removed, and we're going back to the old law where parties have to, it's mandatory to conclude bargaining. So, if you didn't like each other in a bargaining environment, union and employer, one or both parties could be quite toxic and obnoxious and obstructive and just not settle agreement currently. There's going to be a requirement to actually settle that, and if you can't do it yourselves, there's going to be interventions through the authority or the court. They changed the law, the past government changed the law again about when you could initiate bargaining. It was a 60-40 day rule. Union could initiate 60 days out from a collective expiring, and the employer could initiate 40 days out. That was brought into the same time frame by the previous government. This government's taking it back to allowing the unions 20 days advance notice to initiate bargaining. As I say, forward to the past is quite a good term. That's my term. Removing the ability to opt out of a multi-employer collective, and this is where some of you might want to have some interest. Multi-employer agreements are where there are a whole collection of employers typically in the same sort of industry. So it might be engineering, for example. So we've got, engineering employer A, B, C, D and E. Employer A might have a collective agreement with a union and a big, strong union membership. A multi-employer agreement is where the union initiates bargaining not just with employer A, but B, C, D and E as well, even though you may not have union members or you might not have a union presence. They can actually say, we want to basically rope in or bring in businesses of a like kind so we can get a collective agreement with all those businesses. Currently, you can opt out of that. You can say go away, don't want to be part of a multi-employer agreement. The new law, or the change in the bill that proposed is that you can't say no to that. So if you're in a predominant industry that is unionised, but you aren't, then you could possibly anticipate this multi-employer collective environment starting to occur. Again, whether you like it or not, it's about providing the motivation and the steerage for unions to gain a better membership and impact in workplaces. Another one is requiring rates of pay to be codified in an employment agreement. My experience is mostly they are. Not quite sure why that's there. You very seldom negotiate a collective agreement, I can't think of any actually, where you haven't actually stated what the pay rates are, even if they're minimum pay rates. And again, requiring collectives to state a rate of pay in the actual document itself. Here's where it gets tricky. Quite a significant change, but again, not particularly different from what we did have in place. And you might remember the 30-day rule. I think it was affectionately referred to that if you had a collective agreement, for the first 30 days you had to offer all new employees that collective agreement, and they could pick and choose whether they joined the union and became a party to that collective or went off and negotiated an individual agreement. That's probably not going to be very different. But what is going to be different is that as an employer, where there is a collective, you're going to have to provide all new employees with that collective agreement. And that's probably part of the old law, really. But the other bit is you're also going to have to, in a sense, market the union for the union by providing the details of who they are, where they are, how to contact them, and all those sorts of things. And I find that'd be pretty interesting, I think, in some context. But if you are a bigger workplace and you do have a union presence, be mindful that that's what's proposed in the bill in terms of you providing that information about the union to all your new employees. Again, giving people the option to join the union and join the collective, as opposed to an individual agreement. That's probably not a lot different where you are unionised at the moment. Another little prickly icon of this change in law is the second to last bullet point, where the law is going to require you, if you are a unionised environment and if you have a union collective, to actually notify the union of all your new employees. Now, there is an exemption or a bailout provision that a new employee can say, I don't want you to pass that information on. But you're going to have to find some way to collect that information from that employee. So just to put that in context, I'm employing Dave Robb to come and work at my unionised engineering site. Dave, I've got to pass your details on to the union because you're a new employee. I've got the option of saying yes please or no thanks. But for you as employers, where this might impact on you, you've got to think about how you're going to do that. Another piece of paper, another form, another box to tick. I'm not sure what the answer will be. But that has got some interesting, two of those things have got an interesting perspective in terms of promoting the union through your business. Just have a quick cover off of the triangular employment relationship. As I said to you, it's not about music, although for some it might be music to their ears, but this is really where you've got the employer A who employs let's say an engineer. They send their employee to another site, a different company if you like, or a different employer B, and the government is trying to influence the nature of that contract or relationship in terms of what actually happens. what they're really saying is that if employer A does not have a collective agreement, but their employee works with employer B, and employer B has a collective agreement, then employer B's collective agreement terms have to be provided to that employee of employer A. You with me? I think you are you? Haven't explained that very well. Really, what it's really meaning is that if there's a collective agreement on a site where one of your employees is working, and that applies to them in terms of the kind of work they do, then there's a good chance that that collective agreement is going to apply to that employee of yours. That's only where you're sending people off to work with other agencies or other employers. For example, Labour Hire Limited employs a builder. They then subcontract that builder out to ABC Limited to perform the work. In that example, or this example, Labour Hire Limited is the primary employer and ABC Builders is the secondary employer. What the bill's saying is that the primary employer can be bound by a collective agreement on the secondary employer's site, where that applies to the kind of work that's being done, or that's being done. There are some provisos there, and that is that the employee is a member of the union that's party to that collective agreement, and that the employee isn't bound by any other collective agreement. So that's that triangular relationship, and it's all about probably breaking down the practice that we have quite predominantly here in Hawke's Bay of, company A providing a worker or employee or whatever to company B. And I think you're going to have to think very carefully if you are in that kind of business where you engage a lot of contractors and where you are a collectivised site, what are the implications for you in terms of using those contractors, both for your own business but also for the contracting business. Contractor is usually employed by a separate, either self-employed or employed by a separate employer working on your site. Fixed term is usually a direct hire employee, but for a fixed term period. So you're employing them directly. Well, I could use an example. I don't know whether this is quite, let's say ABC Labour Hire Limited provide seasonal staff to Heinz Watties. If those seasonal staff are union members of the labour hire company but are working on the Heinz Watties site, Heinz Watties have a number of collective agreements that worker from the labour hire company, if they're a union member, would be bound by the collective agreement terms at the Heinz Watties site. So talk about complicated. Well, no, it's the way the bill's framed is that they've got to be offered the collective terms at the Heinz Watties site.
Even if it's less?
Could they decline it? Offer them a different?
Well, if it's less, you probably would, wouldn't you? Yeah. But the way it's been programmed in thinking is that most labour hire companies, I don't believe this, but they're thought of as being quite miserable in terms of what they pay people, and they're actually making some sort of margin out of the labour that they hire out. I guess the government's agenda is to try and equalise or provide equity in that kind of relationship. One of the key things, though, will be if employer B moves that person on, i.e. or dismisses them in any shape or form, employer B and employer A could equally be brought to account for an unjustified dismissal. So we're not only going to have that complexity of the employment relationship and terms, but you could have two employers in the same room trying to defend why a person was terminated or dismissed through a personal grievance process. So it's going to be really interesting. Well, just for me, sorry, but it's going to be looking pretty complicated in terms of that tripartite or triangular relationship. And so watch this space. It is a different bill, but it's certainly got some momentum from the current coalition government because they are trying to address what they believe are some of the wrongs of that sort of relationship. So just to round off really, before you have any more questions, if you do, as I said, the first reading for the Employment Relations Amendment Bill was in February. It's now going before the Select Committee. If you're deeply ingrained in reading bills and you believe that there's something inherently wrong with what's in the Employment Relations Amendment Bill, please think about making a submission to the Select Committee. You don't need to attend. You can actually submit a written submission to the Select Committee. And the Minister is actually saying, I think genuinely, that the government wants to engage with employers, unions, employees in terms of this legislative change. And if you think there's something badly broken with what they're trying to do, I think they want to hear about it. No guarantees anything will change, but I think you need to make sure that if you can see some operational or systemic or legislative issues around what's being proposed by way of this bill or these bills, you need to speak up. It's the only way that you'll see change. There are a few more steps in the process. It's once the Select Committee reports back, there's more processes of reading the bill in government, and then there's a final reading, and I suspect it will then pass into law. And the way it's structured at the moment, there'll probably be about a 4-month wait period between the new law receiving royal assent and being implemented. So that's that transition provision. That's the time you really need to be aware of what's happening and make sure that you've got your business systems and processes, your agreements or whatever, well sorted for that situation. Again, the pay equity and equal pay bill, I did touch on that. It does have implications around what it's going to do to remuneration frameworks and such like. But again, it's a bill that's looking to address, I guess, pay inequity really, and inequality, particularly in a workforce dominated by women staff. In terms of how we can help, you expected this, I'm sure. Complimentary session, no, I've got to do something like this. But no, look, seriously, we will be staying ahead of what's happening in the law. If you use our employment agreements, then we'll be making sure that you're very clear on what might need to change as a result of these bills. Again, I think, Emily, you mentioned the performance management around the probationary period. If you need some skills or some help around that, then we're there to help, as always. The other thing is that pay benchmarking and remuneration framework that I talked about in regard to the pay equity bill going through is how are you going to address those people who say, I've got more pay through the pay equity process or through the minimum wage process, and how are you going to address those staff or those people in your business who are saying, they got more, I want more? I don't have an answer yet, but that's well worth thinking about. So, you know, your strategies around pay and benchmarking and remuneration are really important. I think too that we're going to see a changing workplace environment. You know, we're not 1960 or 1970 or 1980 anymore, and I think you need to be thinking about not if the law changes, but when the law changes, what you're going to be doing to make sure that your workforce is engaged. You're attracting good people to your business and retaining them, and that you've got a culture of really highly motivated, engaged people, because law change won't make a difference to those things. The law change sits in the background. It's what you've got to do. It's what you can do that really matters with your people and your business. Again, if there are changes in the law or the bills as are proposed, then if you've got policies and procedures and handbooks that are inconsistent with the law, you are going to have to make changes there as well. Yes, I know it's happening all over again, but again, that's what happens when you get a change in law. And certainly, look, if you've got a collective bargaining environment, or if you are starting to get interest from a union, we've got some pretty good staff who are well used to working in unionised environments, and we've got some pretty good processes around dealing with that situation. You can't, as I say, tell unions, or you won't be able to tell unions to take their marching orders and leave the place, but you can actually manage that relationship and manage that dynamic quite well through some pretty clever strategies and some good leadership strategies. So thank you very much for being here. It's been a great turnout. We're just delighted that you could take a bit of time out of your day to be here, and if there are any further questions, we can have them now, or you could talk to us afterwards. We'll be here for a wee while afterwards, and I hope it was a useful session.